Melanie.
Hey, good afternoon, everyone. I hope you're all well and safe. No, it's an interesting time for all of us, so I decided to cheer us up a little bit. And I've invited Melanie from Southeast Lawyers to join us here at Got Money. Our discussion today is challenging wills. Melanie, welcome to the show.
Hello.
Challenging a will. Like I had a family member, very, very wealthy family member that passed away, and my uncle challenged the will. Very, very expensive exercise, isn't it?
Mm-hmm. It is.
Can anyone challenge a will?
No. So the starting position in Victoria is that a will maker has an obligation to make provision for certain people in their life who would be negatively impacted by their death. So I'm not sure how long ago your uncle's will challenge was.
It was in New Zealand too, but it was about maybe 10 years ago, quite a long time ago.
So before we had legislative change in this area, every Tom, Dick and Harry were challenging wills. Ex-partners, grandchildren, the guy who mowed the lawn, all of these sorts of things.
Yeah.
But thankfully, after much public outcry, Victoria's categories of people who can launch a challenge has been quite diminished. So what you're looking at is basically a spouse, whether it's married, de facto, domestic relationship. You don't necessarily have to live together.
Okay, but if you've had a relationship with that person, you're able to? Okay.
Yes. If your relationship has been secret behind closed doors, that is a bit of a problem. But we've still seen cases get up on that. So spouse, children. So in relation to children, it can be obviously your own biological children. It is children you have adopted. And it can be quite broad there. It can also be children who have grown up thinking that you are their parent, and it comes out on their death that actually, no, you were something else.
That happens a bit, doesn't it?
Yeah, a little bit still. So that's an interesting one. If you have a child that you have adopted out, then they can't challenge your estate. If they have been formally adopted by somebody else, then basically that is the new parent's problem.
So tough. You can't, no way back.
Yeah, and also grandchildren. Grandchildren have been introduced as a category, I think, to acknowledge the fact that a lot of children are living with their grandparents under the support of their grandparents. So they really should be looked after, despite the fact that they may have their own parents. If a grandparent is providing a level of care, then that is a category to which a challenge could apply.
So if the person that is deceased is taking care of, say they're financially taking care of a neighbour.
Yes.
Because they like the neighbour and they get on really well. Would the neighbour be within their rights to challenge the will?
No.
Okay.
No.
So it has to be really immediate family that have the ability to challenge a will.
Yes. And a really important part of that is that even though you might hit one of those categories, it still comes down to what reasonable provision is. So say that your mother passes away, you're a multimillionaire yourself and she's cut you out of her will, or not made provision that you think is sufficient. Just because you're a child, I mean, you've ticked that box, but you've got to have a need yourself. And different siblings can have different needs, and they may end up with different amounts from an estate on a challenge. If you can't show need because you're wealthy yourself, then it's unlikely that you're going to be successful in any challenge, even though you can bring it.
So I had a neighbour who's deceased. I'm making this up, by the way. Let's make this up. I've got a neighbour who's become deceased, and he has 4 children. And does he absolutely by law have to make provision for all 4 of those children?
So you can make your will any way you want in Victoria. You can leave it to Santa Claus for all we care.
And we like Santa. He's a good dude.
Maybe the Lost Dogs Home, you know, you can do that.
Yeah.
But then after the fact is where the challenge may come. So I always say to clients, these are risk factors for a challenge, but if you want to leave it all to the Lost Dogs Home and wing it that nobody will challenge, take your best shot. Like, it's your estate. So you might find in cases that you've got different provision made for different children. So child A might get 50%, child B 25%, child C 25%. Or you might see a situation where it's just 25% each across the board. There is no specific percentage to hit that will make you safe in this regard.
So anyone within the immediate family could sue?
Yes, so spouse, children, and anybody that you live with that has an interdependency type relationship, even if you're not related. So think along this line. Say you've got a family that has 3 children. One child has significant special needs. One child is financially well off, and then you've got one child on Centrelink benefits. So as a testator, a will maker, you should be looking at that and saying, okay, well, do I make more provision for the person that is suffering under a disability because they do have higher needs? Do I do that by taking provisions off the one who is well off? What about the one who is on Centrelink benefits? They've obviously got needs as well. Some people seem to think there's a specific amount that you can hit to stop people challenging your will. So the popular one seems to be, if I leave them $10,000, they can't challenge, which is not true.
Okay.
It's all about need in this scenario. So sometimes you will get an interesting case where all your beneficiaries have some kind of need themselves, and then that's a very hard thing to balance.
Yeah, that must be a bit of a nightmare to manage that if you're in the process of writing your will, because there's the other side of it too. When you get older, there are some people within the family dynamic that you have a better relationship with the others, and that can be reflected by taking care of them financially after you've gone. But it sounds to me like there's really no way of mitigating the impression or the interpretation of everybody that's in that estate. Because look, I'm a gay woman and I don't have any children, but I've got nieces and nephews that I love, all of them. I really love them. But some of them will get more than others because, hey, let's face it, some of them I really, really like, and some of them, you know, if I don't
I'm with you on that one.
And not me being disrespectful, some of them I could hang out with all day, all night, no drama. But others, hey, is it Christmas? Sorry, I've got a headache. So, but the ones that I feel that way towards could really just turn around and make it quite disastrous for the ones that I really care for. So is there nothing that can be done to mitigate the risk to the ones that I actually care for?
Well, a couple of things. So in your scenario, nieces and nephews don't have a right to challenge an estate unless they're living with you and you are caregiving for them. So you can make it up as you want. You can cut somebody out and they can't do anything in your situation. But if you had a situation where you had children and you didn't see some of them very often, you'd had a falling out. If you tried to leave it to your favourite children, then the kids that you've had a falling out with, they may be able to challenge even though that relationship wasn't there. So there are ways to do this. They are not all convenient ways, and some of them are expensive ways. So the first one is basically the first one, the best one, the bulletproof one, is to move assets out of your estate before you die. Because, yeah, I know it sounds dodgy as, but if it's your money, it's your asset, then if you remove it from outside your estate, and what I mean by that is perhaps you put it into a trust or into a company that, whilst you control, is a separate legal entity. So if you've removed it outside your own asset base, then when you pass away, you're not going to have anything in your estate to challenge. So even if you had a beneficiary who would be successful in a challenge, if there's nothing there, you can't do it. And that can't be challenged. I've done it myself in many cases, and I've had
just showing off now, aren't you? You're
I am.
I've done it. Been there, done
and
that.
I've had disappointed beneficiaries come back and say, hang on a second, we thought Dad had a house. Well, no, Dad didn't have a house. He sold it, and he lived in rented accommodation, and he put that money into a trust, or he gave it to other children during his lifetime. If the asset is not there, then challenging the will is a waste of time and money.
Let me ask you something. If, say you don't have the benefit of having you as a lawyer, and you contest the estate as a child, does it then sit as a frozen asset or a frozen estate? And does the estate or proceeds from the estate pay for all the children to actually take litigation against each other? Is that how that works?
Yeah, that's really important. So the estate does not necessarily have to be frozen, as long as the executor has an obligation to make sure the estate is not dissipated. So it would be stupid for an executor to know that there was a challenge on foot and distribute funds out to the beneficiaries.
Oh, that'd be disastrous.
If that happened, and then a court ordered that the challenging child had a right to, let's say, $100,000 from an estate, the executor would have to try and recoup that from the other beneficiaries. And if they didn't, the executor could be personally liable for that. So I've not seen a case where an executor has distributed, anything beyond a small amount of funds to keep the beneficiaries going, because the risk is too high. In terms of legal costs, we often call this jurisdiction litigation blackmail, because
I could imagine it would be.
Providing that a challenger's claim is not completely ridiculous or outside the scope of the law, then all likelihood is that their legal costs are going to be paid out of the estate, whether that's by way of a settlement or whether it went all the way to a trial. So you've got to think your executor is incurring legal expenses that will be paid generally from the estate. Your disappointed beneficiary who is challenging, it's likely very likely their costs are coming out of the estate. And sometimes there can be more than one challenging beneficiary. So they may each have their own lawyers. With all of these expenses coming out of the estate. So often in those circumstances, as much as the executor and the other beneficiaries may not like it, it's often worth just paying something to those challenging parties to make them go away, because the costs of this sort of action, just to kick off proceedings, you're talking 10 to 15,000 at a reasonably priced firm.
Yeah, just the hello on getting started is quite expensive, isn't it?
Yeah, and then you go through the different document processes and a mediation. And if you go all the way to a trial, which very few of these ever do, but each party could be looking at spending upwards of $150,000.
$150,000 to get it to trial. So let me say
it could be more. It depends on the circumstances of the case, but it is really expensive.
So it would have to be a multi-million-dollar estate for you to even take this on.
Yes.
Let's talk about selling assets. So if something is being, say, siblings are going to contest the estate, and there are assets in the estate, and there's real estate in the estate,
mm-hmm.
Can you start selling off those assets prior to court, or do you have to hold the assets until it's been finalised by the judge?
It depends on what the assets are. Every lawyer's favourite phrase is, it depends.
Yes, you were doing a lot of that during this interview.
I know.
You don't often do that.
Well, this jurisdiction more than any is like, oh, which beneficiary, oh, what day. It's very contingent on circumstances. But if you've got an estate that has assets in it, that would be where it would be beneficial to start selling things down, then an executor can do that. So if you knew that a certain company, the share market was going to fall and you would lose a lot of money, as executor, yes, you would be obliged to sell those shares to maximize the value of the estate. However, the big the no-no item would be if you've got a beneficiary living in the estate property and they intend on challenging so that they can keep the property and have a roof over their head, you would not want to be selling that property down and booting them out until the challenge is sorted.
How long can this process take?
How long is a piece of string?
Yeah.
I would say that once you kick off proceedings, you would generally have a mediation date between 5 and 6 months of kicking everything off, although that has obviously been impacted by COVID. Courts are running on a skeleton staff, and whilst we're doing mediations like this over Zoom, there still are delays. If you couldn't settle at mediation, then it could be another 6 months or more to trial. So you potentially have this hanging over your head for a year or more, depending on the different cases and the different facts. So that is one thing that you'll find a lot of people get litigation fatigue about. What we call litigation fatigue. I can imagine they
would. What about as a lawyer remaining calm in that? Because I can imagine that would be highly charged and very emotional for all the parties concerned.
Oh, definitely. And what you will find is that for most people, it's the principle of the matter.
Oh my God. That's a bumper sticker, that one-liner. It's the principle. 3 words.
Yeah. Whether you're an executor, whether you are somebody challenging an estate, whether you are a beneficiary who is not challenging the estate and is sitting back and watching this, a lot of it is about the principle. You know, how dare my parents cut me out after I've done everything for them? How dare this person challenge my parents' estate? It is very emotional. And the problem with that is at the end of the day, it will come down to money.
It's all money.
And it's very hard to accept that as a beneficiary, as an executor, as a challenger. You know, we can't make a deceased person give an apology, and we can't make a family member admit that they shouldn't have had X amount of money, or that somebody else should have had Y amount of money. At the end of the day, you will generally get a cash settlement. That does not necessarily comfort you at night, because this is all about fractured relationships.
Yeah, that's it, isn't it? I mean, if it is, it is. And the other side of it too is this kind of, my dad died and he left a watch to my, I think to my nephew or to my brother or something. And it became fractious between the siblings. And it's just like, well, at the end of the day, if that's what Dad wanted, respect whatever dad wanted. Who cares? It's none of our business.
Yeah, we see that a lot with personal items, and generally speaking, unless the personal items are worth a lot of money, you know, your Rembrandt or your Da Vinci painting, the court doesn't much care about that, but they are really personal items. We have had cases where clients have agreed on the financial side of things that X person's going to get this and Y person's going to get that, but they are fighting about things like family photographs, war medals, sometimes the cat.
Well, not the cat.
Yeah, sometimes.
Do people tend to settle during mediation? Is mediation like the point where you go, okay, come on, this is game on now, let's get this done?
Pretty much. The amount of these cases that actually go to court are quite small, and it's usually where there's something very unusual, or where somebody really digs their heels in and says, I don't care if this is becoming uneconomical, I've got a point to make. And they're really hard people to negotiate with.
Step parents, and I've got a family dynamic where there's a step mother, and that kind of got pretty nefarious during the settlement period for these family members of mine. Do you see that a lot? Is it around the step parent?
Yeah. So the step parent issue and the blended family issue is something that needs to be considered way in advance, obviously, of you passing away. And it's a really tricky situation to plan around. So you see a lot in the media at the moment about different do-it-yourself wills or online wills. Most of those wills do not contemplate your blended family situation. They ask very specific questions, and it really leads to a will that's very straightforward for your average nuclear family.
Yeah.
Whether that's in the heterosexual, homosexual, gay, whatever. That family of two people, some kids, but where you've got people who have a second marriage, a second relationship, they've pooled their wealth, they may have children at different ages and different needs requirements. That's definitely where you need to get a lawyer involved to give you some good advice, because generally speaking, a person's first obligation is to their spouse. It's not phrased in legislation that way, but that is the way we've seen the case law, because it assumes that if you give everything to the surviving partner, they will look after the children, because it's their children, which is not necessarily the case.
No.
So it's really important to be able to look at the assets of a couple as a whole, what their situation is, and including looking at superannuation and saying, okay, well, how do we best balance all of those different things? Because the classic case is the couple re-partner, they leave wills that say, all right, when the first one goes, everything goes to the second one. So first one goes, everything goes to the second one. And then the second one does a new will that says, right, it's all going to my kids or the lost dogs home or whoever. The first to deceased children may be able to challenge that. But then you're back into that whole challenge paradigm, spending costs, etc. So there are various strategies that can be used to better balance those different obligations. But yeah, your simple mum and dad will doesn't cut it in that sort of situation.
So really, I guess the upshot from this is, if, you know, firstly get a will drafted correctly by Melanie. Do you like how I did that?
I do. I just wish you'd do yours.
I know. We could dig into that, but I should really do it, shouldn't I?
You should.
Get through COVID.
COVID is the perfect time.
What was it last time? What did I say to you last time? Let me just get through blah, blah. So have a will drafted correctly, particularly if you're a mixed family. That sounds to me like that's really, really, really important. Talk to me about executors of estates. It's important to have someone that's directly connected to the family. Can it be a lawyer or a friend?
It can be a lawyer. So usually what you will see is somebody appointing their spouse as executor, and then if both parties are gone, appointing children, 1, 2, a combination. You can have up to 4 people acting as executors in Victoria at any given time. It's very messy. I wouldn't suggest it.
What do you suggest then? What's the easiest one to manage?
The easiest one to manage is where a couple make each other first, they're executors.
Yeah.
And then from there, it really depends on the requirements of the estate, because if you have children under 18, obviously it's not appropriate for them to be executors. There are various different options. So you can have someone in the family, aunts, uncles, sisters, brothers, cousins. You can have friends, you can have lawyers, accountants, you can have professional trustee companies, which can include the state trustees, although I wouldn't recommend that.
Oh God, no.
And what it's really important to think about is, firstly, if you're going to do a will that potentially has a challenge element to it, to be very picky about who you choose to be executor, because you might appoint Aunt Flo, but she can't handle litigation. She's very much a stress head. That's not a good combination. So that really needs to be carefully thought about. Yeah. And certainly executors, accountants, the state trustee will charge to be an executor, but it's often good to have that independent party.
You kind of need you need somebody that's kind of not emotionally attached to the, because it can be quite fraught, can't it? Particularly after the grief of losing a family member, then having to step into that as a paradigm would just be a nightmare.
And you need somebody who is competent with these sorts of decision-making situations, who understand financial matters. I'm not saying that, you have to appoint your brother who is an accountant, but we've had a variety of different cases where the executors just cannot cope. For example, there's not much point appointing somebody who can't read and write, because how are they going to be executor? How are they going to know what to sign? And whilst you might think there's such a small proportion of people in Victoria like that, there are people like that, and it makes it extremely hard to discharge their executorship because they can't deal with assets. They can't read and sign. Well, they can sign, but they can't read and understand.
Yeah, so there's a whole lot of factors involved, isn't there, that need to be considered. And you do that with clients too, though, don't you? You sit down and kind of eke your way through that with them.
Yeah.
So it's just not advice. I mean, I think my mum's got a $45 will kit, and I just, jeez. And you can't read handwriting anyway. I mean, it's like a drunk ferret went walking through a postcard.
The will kits are certainly a problem in the will challenge area, because people fill them out without having legal advice, and they don't go through this thought process of, okay, I've got the blended family, these are the provisions I need to make. So even if they can fill it out properly, they don't have the background to understand how it might play out in the future. And therefore you're just creating an environment that is ripe for a challenge. So the first thing I would say to people is, A, make sure you get your will properly drafted to your needs by a lawyer. The second thing is to, if you've been cut out of a will, seek some legal advice. The Law Institute of Victoria offers 30-minute free consultations with some lawyers, so you can get information that way. A lot of lawyers also have an initial consultation fee that's less than their normal fee, so you can get some specific advice. Don't listen to the person down the pub who says you've got a right to challenge, or you don't have a right to challenge, because every case in this realm is different. And often you won't know how your case is different to the guy who's down the pub. What he's saying might be relevant for his case, but may in no way, shape or form apply to your case.
Legal advice. Just start with legal advice. Get a good lawyer. In fact, get in front of it and have your will drafted by someone as competent as Melanie, and that way you're mitigating most of the risk. Thank you for joining me, mate. I really appreciate your time today. You've been amazing. You will be doing my will. Do you like how I end it? Take care, everybody. Look, if you need anything from the #GotMoney team, please feel free to reach out. If there are any topics that you'd like us to cover, we would just dearly love to hear from you, and we'll certainly take care of that for you. Be safe. We'll be thinking about you. Take care, everyone, and all the best. And we look forward to being here again with you next week.